G'day everyone, welcome to another 360 Partners video. Today we're going to cover a topic that is relevant to many small businesses in Australia, and that is commercial rent relief. So let's get into it. So commercial rent relief, well, what is it and why is it important? Well, you probably recall in April this year, Scott Morrison announced that he was making a mandatory code of conduct to compel landlords to negotiate with their tenants regarding rent relief for their commercial leases, and most commercial leases are included in that program. So it's important because commercial leases are probably one of the most significant costs to the average small business, probably second only to human resource costs. And we've got the human resource costs that are being subsidised by the JobKeeper program at the moment, so that's being there's a lot of assistance there, but wisely the Scott Morrison government also saw the need to manage commercial occupancy costs, so they've created this mandatory code of conduct. Now the reason they created a code of conduct was that federal government doesn't manage legislation for tenancy law. That's a state-based legislation, so each state has gone on to create and amend their own tenancy laws based on this federal mandatory code of conduct. So the mandatory code of conduct basically had an overarching principle that landlords and tenants would negotiate in good faith to produce rent relief outcomes so the businesses could survive. We think it was a pretty good idea to have prescriptive requirements in here because frankly could not see landlords voluntarily taking rent reductions just out of good faith. It just probably wasn't going to happen. So there's a range of requirements in the code of conduct and in the various state legislation now that must be adhered to in any changes in leases. There's about 14 principles in the Prime Minister's code of conduct. There's a handful of them that are particularly notable. Landlords aren't allowed to terminate leases basically in this 6-month window to the end of September. Tenants also have to remain committed to their leases and endeavour to fulfil their obligations, so it's not a case of just do whatever you like for the next 6 months as a tenant. Landlords must offer proportionate rent relief in the form of both rental waivers, which is basically discounting the rent, but also rental deferrals, which is saying you can pay the rent later. So they have to be a combination of those, and the guiding principle is that no less than 50% of any rental concessions can be, or has to be, complete rental waivers. The other 50% can be deferrals. Now you can negotiate between you a different outcome, but that makes sure that tenants are going to get a significant reduction in their actual rent cost, because there's no point just having deferral where at the end of 6 months you've got to pay it all when you reopen your business. So it's a pretty good program. Landlords must not use any of the tenants' bonds to draw upon to pay any of this rent. Tenants should be provided with an opportunity to extend their leases, and landlords also need to agree to freeze rental increases. So they're the major principles, and each state went on to implement their own subtle variations of that. Notably, some states like Victoria, for example, doesn't have a proportional reduction clause in there. So in terms of how much rent relief your landlord is required to offer you, in Victoria it's basically a negotiated outcome, whereas the federal mandatory code of conduct said that it had to be proportional. So in that, for example, proportional would typically be interpreted as if your business was forced to completely close and therefore had a 100% reduction in your turnover, then you would expect to be able to ask for a 100% rent relief package, which would include deferral and waiver of rent. But the state, some states like Victoria have not put that proportional element in there, so it's purely up for negotiation. In terms of eligibility to fall under this mandatory code of conduct, well, you have to have an eligible commercial lease, which a lot of small businesses have. The small business has to have turnover of under $50 million a year, which most small businesses have. And importantly, the small business has to be eligible for and enrolled in the federal JobKeeper program. So if you tick those three, then as a small business, I'd highly recommend that you, if you haven't already, approach your landlord. They are required within 14 days of you making the correct application. They are required to come back and offer you a rent relief package. In terms of applying to your landlord, you must put it in writing. You must state that it is an eligible lease, and you must give them information to verify that your entity is enrolled in the JobKeeper program and has experienced a decline in revenue as a result of the pandemic. So raises some interesting questions and privacy issues, because the landlords are allowed to ask you for reasonable information to evaluate how much rent relief they should give you. And that's probably quite fair, because they're evaluating how much to reduce your lease by, which comes out of their pocket, and you need to provide them with evidence and justification for doing that. So you should expect to need to provide potentially some BASs, potentially some financial reports. As accountants, we've seen a lot of these requests coming through. Some have been fair, some have probably been a bit over the top. We've seen people asking for forecasts, and I think real estate agents have some standard letters they've been sending out. Some of it's probably straying into unreasonable territory. They're not, for example, allowed to ask for audited financial statements, which can get quite expensive to prepare. Forecasts can get quite expensive to prepare as well, depending on what they ask for. So they're allowed to ask for reasonable information. I would suggest that you provide it to them. At the end of the day, it's going to result in a faster outcome for you, and they have 14 days once you apply to come back, and obviously you can negotiate from there if you're not happy with what they've offered. There is dispute resolution process in most states. Victorian Small Business Commission can hear mediation. You can take it from there, I believe, to the Administrative Appeals Tribunal if things don't go well. So there is a requirement that landlords come to the party and negotiate. I would strongly recommend, if you're a small business, that you look at doing this. Potentially speak to your accountants, and it'll help alleviate some of the cost burden of your lease for the next 6 months. If you've got any questions about that, please feel free to post them on our Facebook. We'll certainly try and answer them. Otherwise, we'll see you next time.